Associate Justice of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sitting en banc is now in session. Please be seated.
Good morning. Welcome everybody to oral argument before the California Supreme Court in our Los Angeles courtroom. The clerk may call the calendar, please.
Good morning. The Supreme Court of California hearing oral arguments in Los Angeles on Wednesday, April 3rd, 2024 at 9 a.m. Case number S279242. Make UC a good neighbor et al. Plaintiffs and appellants versus the Regents of the University of California et al. Defendants and respondents. Resources for Community Development et al. Real parties in interest. For respondent, Ms. Nicole H. Gordon. Oh, sorry. And for appellants, Mr. Thomas N. Lippi. Case number S273179. Truck Insurance Exchange, plaintiff and appellant versus Kaiser Cement and Gypsum Corporation et al. Defendants, cross-complainants, and appellants. London Market Insurers, defendant and appellant. Insurance Company of the State of Pennsylvania, cross-defendant and appellant. Granite State Insurance Company et al., defendants and respondents. For appellant, Truck Insurance Exchange, Mr. Robert A. Olson.
Ready, Your Honor.
And for appellant, London Market Insurers, Mr. Brian A. Kelly.
Ready, Your Honor.
And for appellants, Kaiser Cement and Gypsum Corporation, Mr. Philip E. Cook. Case number S273887, Michelle Himes, Marsha Benjamin, Daniel Benjamin, individually and on behalf of others similarly situated, plaintiff and appellants, and Jose Riera, Deborah Chase, and Diane Skura, plaintiffs, versus Somatics LLC, defendant and respondent, and Mecta Corporation, defendant. For appellants, Mr. Bijan Esfandiari. And for respondent, Mr. Jonathan M. Freeman.
Thank you. Calling the first matter, Make UC a Good Neighbor versus the Regents of the University of California. Good morning, Ms. Gordon. You've requested 20 minutes for your opening.
Yes. Good morning, Your Honors. Nicole Gordon on behalf of appellants, the University of Berkeley, and the Regents of the California University. We appreciate the opportunity to be heard on the important matters this case presents. As you know, the legislative landscape has shifted since this court accepted review in May of last year. Since that time, the legislature has stepped in with urgency legislation that directly responds to those issues that the Regents petitioned this court for review. And the project opponents have conceded unequivocally that as to the People's Park Student and Supportive Housing Project, the legislation resolves the issues pending with respect to both social noise and alternative locations. I would like to reiterate our request that this court reverse the Court of Appeals decision as it applies to the People's Park project with directions to the trial court to affirm the trial court's judgment as to both social noise and alternative locations as it applies to People's Park. And if there are no other questions or any questions on the People's Park project itself, I'd like to move on to what else is left in this matter for this court to resolve. Thank you. As you know, the new public...
I think you will have questions as we go along. It won't be that easy, but... But to place this in context, you've started off by saying that there are concessions, important concessions here in light of the new law. So I think you have to be living under a rock to not know what the controversy is surrounding People's Park. But the new legislation now has substantially narrowed the issues before this court, correct?
Yes, Your Honor.
And as we stand here now, there's no argument any longer with respect to social noise impacts as to this particular site. Is that correct?
That's correct, Your Honor.
What about more broadly, the argument seems to be that there still is a component that we should consider, and that's the social noise impacts resulting from the increase in the population from more students at the campus, regardless of where they live.
Exactly, Your Honor. Thank you. That is right where we were going to go. So the Court of Appeals decision does address both the People's Park project and what it refers to as the development plan, the long-range development plan. And the legislation, Public Resources Code 21085, mentions residential projects specifically. But the legislative history of this bill clearly shows that the legislative intent was not just to limit application of this rule, that social noise, the noise from people going about their personal, private lives, should not be a CEQA impact to only residential projects. The legislative history shows that the purpose of the law was
So you're talking about legislative histories. Does that mean that it's not clear on its face in terms of its application?
No, Your Honor, I think it is clear on its face that it is meant to apply to residential projects. But as the project opponents have invoked this maxim that by mentioning residential projects, the legislature somehow intended to exclude anything that isn't a residential project, I think that opens the door for us to have to look at the legislative history to make sure that there isn't a contrary intent there. And here there is a contrary intent. Here the legislative history shows that the purpose of the legislation was to reestablish existing precedent that CEQA was never meant to be used as a tool to police nuisances and intermittent noise violations like the kind at issue here.
So can I ask you, how would you have us interpret the phrase residential projects as it appears in this new provision? Does it apply to any project that has any residential component whatsoever? Are there any limitations on what qualifies as a residential project in your view?
The legislation does not define the term residential project. The other piece of legislation that went along with AB 1307 does, but it doesn't define it, so I think it can be interpreted extremely broadly, and I would interpret it to be any project that includes a residential component. And here, the long-range development plan, a large component of what that plan does is propose future residential student housing projects. So in addition to the People's Park project, there are 11,000 plus beds proposed under the plan, and I think the legislation clearly would preclude the Regents from considering the noise impacts from any resident in those projects to be a significant impact under CEQA.
But does it mean that we don't consider going forward any social noise impacts resulting from the non-residential aspects of the long-range development plan or any other project that might include both residential and non-residential components that we might encounter in the future?
I think it means that for residential projects, definitely. I think for any non-residential project, commercial activities, general plans, anything doesn't have a residential component to it, that the legislative history plus the long body of case law that we've cited in the opening brief and reply brief on the merits before this new legislation came out demonstrate that CEQA was never intended to be used to police the individual people that a project will serve when they're going about their private daily lives and not doing anything that's associated with the use of the project itself.
Council, could you just briefly summarize what is covered by the long-range plan?
Yes, thank you, Your Honor. You took me by surprise over there. The long-range development plan is a framework for the university's academic and residential growth. So it looks at the anticipated population growth over the next 15 or so years, and it plans for what infrastructure, what buildings, what facilities will be needed to accommodate that growth should it come to the campus. As the Court of Appeal found, the long-range development plan does not cause the growth, it simply accounts for it.
And Council, does that accounting include both residential growth and non-residential related growth?
It does. So the population growth that is included and analyzed in the environmental impact report includes both non-residential and all of the other growth that would occur, both physical and from the campus population. So in areas like transportation and water supply, the EIR looks at all of the impacts from the growing campus population as it's required to do under Public Resources Code 21080.09. So even though it's not causing the growth, it does look at it. And even in the case of noise, the People's Park project analysis for noise looked at people who might be gathering in the open space that will be built as part of the project, and whether that noise would result in a significant impact, because that's a use that's associated with the project. It didn't look, though, at how students are going to conduct themselves when they leave campus and go to currently unplanned private parties in the city of Berkeley that aren't sponsored in any way by the university.
I guess I'm kind of wondering whether it's easily disentangled what is residential versus non-residential in the context of what sounds like a fairly integrated plan. I mean, the thought would be that the growth ambitions of the campus, I mean, a linchpin of that, one would think, is the ability to house people, because if you can't do that, then many of the other things can't be done either. So this goes back to Justice Kruger's question about what is a residential project. Can you help us in terms of how we might separate what is non-residential versus residential in a integrated plan like this?
I will endeavor to do that. The 11,000 beds that the housing program provides, I think certainly those 11,000 approximately students would be considered project occupants. And then the legislation talks about their guests. So these are project occupants and their guests of residential projects. And I think that is hard to define because we don't know who these people are and whether they're going to be part of the campus population or not. So I think that to the extent the long-range development plan has these residential projects within it, you could read the whole plan to be a residential project under that definition because it has some component of residential. But I think the better way to look at this would be to consider the limiting principles of CEQA that have always been in place and that would apply to the campus population growth in general, whether or not people are going to be living in quote-unquote residential projects. I don't know, I'm looking at you, but you're not there. Whether or not they'll be living in residential projects, because never before has CEQA been used until this Court of Appeals decision to try to account for how people are going to behave, not just when they're living in a residential project that's part of a project here, either the long-range development plan or a specific future residential project, but when they go out into the neighborhood and make personal choices, and the Court of Appeals decision, if it is not reversed, is, I believe, confusing as to that point, because it does talk about the development plan in addition to the People's Park residential project. So I think it's necessary to make it clear that that is not the intention, and I think the legislative history provides the rationale for that, that it is never okay under CEQA to police people and their noise with anything other than the local noise ordinance. That is the appropriate way to deal with these issues.
Would it be sufficient for purposes of this case to conclude, based on the legislative history that you have pointed to, that whatever residential project in this new legislation means, it does mean the residential components of the plan that we're talking about here, since this was sort of the focal point of the legislative debate? And we can leave for another day questions about how to sort of draw the line between residential and non-residential components of other types of projects, including other aspects of the long-range development plan that really aren't sort of at issue in this case as it's presented in this court. But for present purposes, it's really, it seems at least to me sufficient, and I'd be interested to know whether you think the same, to say that this legislation at least applies to the residential components of the plan.
I think it certainly applies to the residential components, and I think that the request we would have is that the entire portion of the Court of Appeals decision be reversed, because it doesn't just say residential components of the long-range development plan. It says the development plan as a whole, And the project opponents here have certainly argued that that means the campus population growth regardless of where they will live. So we would request a ruling that makes it clear that the long-range development plan and the environmental impact report that supports that plan is not, it doesn't continue to live in sort of limbo where it is now and is invalidated. And
But the Court of Appeal concluded that the population growth really was not part of the plan for the reasons that I think you've already
Yes,
described
that's
to the court, correct?
Yes, yes.
And the other side petitioned for review of that issue. Does that affect the analysis here because we did not grant that petition?
I think that does affect the analysis. That issue was about the petition review of the alternative discussion, whether there should be an alternative that limits growth. And the court found that no, there should not because the project doesn't promote or encourage or cause growth. I would just want to make sure that any growth, because there is an obligation and the university takes it seriously under Public Resources Code 21080.9 to look at the impacts of its campus population growth as a whole, and it does that. And so we would want to make sure that that analysis is valid and that there's no issues with that. But to that point, because I'm anticipating some things that my opposing counsel might say when he has an opportunity here, as to how you would mitigate for social noise if you were to apply it to the campus population, I think there's a corollary there to the rejected argument or the rejected petition as to the enrollment growth alternative. Because if you were to find that to be a significant impact, there would be no mitigation for that because the project doesn't cause the growth that is really the target of their attack. And so I do think that the rejection of the petition on that precludes the court from looking at it again here. I guess I will move on to just say that we have faith that this court will look at the legislative history, at the long-range development plan, and especially the legislative history explaining that it would never be appropriate to introduce identity-based judgments into the CEQA process, and that this Court of Appeals opinion does that, and we would request reversal of it on those grounds as well. If there are no other questions, I will reserve the rest of my time for rebuttal.
Thank you very much.
Thank you.
Good morning, Justice Guerrero and Associate Justices. Thank you. My name is Tom Lippy for the appellants and plaintiffs in this case. So starting with the social noise impact. I think the court's questions really outline the issue well. The question is, what does a residential project mean in this new section 21085? And so you have to start with the terms that are defined. The term project is defined. It's defined in 21065 of CEQA. And it means the activity that the public agency is considering approving or disapproving, an activity that could affect the physical environment. So here, the housing project number 2 proposed at People's Park is clearly a project that is an activity that could change the physical environment that the legislature decided to exempt from social noise analysis. But the LRDP, the long-range plan, is not a project in that sense. It doesn't authorize the construction of a single residence. What it does, and I think one of the court's questions outline this, it provides a framework to guide future decisions to authorize that activity, the activity being construction of housing. And so the LRDP is not a residential project for that simple reason that it doesn't authorize the activity that would cause the impact. That future decision is left for another day, and here it was left for another day with respect to the housing project number 2 decision, which was a specific project that authorizes the physical impact causing activity. If you take it one step further and look at the question of residential project as opposed to just project, there are two definitions of residential project in CEQA at this time. One is in section 21159.28, subdivision D, and that's in the context of encouraging infill development in transit-friendly or transit priority areas. And it defines it as where at least 75% of the total building square footage consists of a residential use or a transit priority project as defined in section 21155. The importance of this definition is that it's in the context of providing a limited exemption from some of CEQA's procedures. And the purpose is to remove barriers to infill development for housing. There's a housing crisis. There's no question about the legislature's attempts to address that by making limited exemptions from CEQA. And again, in that context, it's the specific project approval that authorizes the activity that changes the environment. Legislature says you're going to get a pass from some of CEQA's procedures.
Mr. Lippy, just again, to put it into context, the legislature seems pretty clear in terms of their view of the Court of Appeals decision and analysis with respect to social noise impacts. They called the Court of Appeals decision on that issue alarming and indicated that alarming with respect to this analysis of, it's been described as people as pollution. Could you speak to that issue and the scope of the actual statute here?
Well, I think that you have to get to the legislative history to get to those statements, and I don't think you do because I don't think the word project is ambiguous. As I've already argued, it's a very specific definition, and there's not, the LRDP is not an authorization for an activity that changes the environment. That's up for approval. It's just a framework. So I don't think you get to those statements. If you do get to those statements in the legislative history, they're not something that the entire legislature voted on. And so the bill's author makes some pretty strong statements of that nature, but the case law that we've cited is that the bill's author...
It's in the committee materials, isn't it?
I'm sorry?
It's part of the committee materials.
It's true. There's no question about that.
And our cases clearly indicate that that can be relevant to a determination of the actual language of a statute.
It can. I'm not denying that. But I don't think it's dispositive. And I think you have a couple of other rules of statutory construction that go the other way. For instance, the legislature is presumed to be aware of case law holding that crowd noise is a CEQA impact. That's the Keep Our Mountains Quiet case.
It's clear they were aware of case law with respect to this legislation.
They certainly were. But they did not, in the actual words of the statute, say that noise made by the occupants of any kind of project is exempt from CEQA review. They simply didn't do that.
Are you saying that the legislature ended up enacting legislation that at least some of the legislatures, including the author, did not intend? I mean, that seems to be the upshot of your argument.
No, I don't think I think the entire legislature did not intend to exempt social noise analysis from CEQA in a broad sense. They did it for a very specific purpose. It's urgency legislation to address a housing crisis. And so the point here is to remove a barrier to the production of housing. And so it's not to remove any kind of burden that CEQA might apply to a long-range plan. And the long-range plan for UC is similar to a general plan for a county.
Right, but let's step back a little bit. As the Chief Justice was asking you, we get a Court of Appeal opinion. The legislature jumps into action with urgency legislation, essentially emergency legislation. We have references in the legislative history to the Court of Appeal opinion being alarming. They reject the Court of Appeal holding in some of the committee reports saying, quote, CEQA did not need to be expanded to include noise from residents. It seems to be a little bit, you correct me if I'm wrong, you're saying that sort of at least that either the legislature as a whole or at least some of these legislatures were acting in vain, that they were acting to address what they perceived as error in the Court of Appeal opinion. And now you're saying, oh, no, we can still block the project. We're not complaining about the project itself, but because issues related to the project get raised as part of a larger development plan, we can still block the project. That just doesn't seem consistent with the entire nature of the urgency legislation as a reaction to a specific Court of Appeal opinion that they seem to be rejecting.
Well, once we start to parse the legislative history as if it's statutory language, if you look at pages 31 and 32 of UC's second motion for judicial notice, and the author's statement there, indicating that it doesn't believe that social noise, or to reestablish existing precedent that social noise is not an impact under CEQA. Those 2 pages show that what the legislature actually was reacting to was the part of the Court of Appeal opinion that was putting in additional burdens on housing project number 2. If you look at that exact paragraph, it starts with a description of the holding as it applies to the housing project number 2. It doesn't mention the holding as it applies to the long-range development plan. So if we're going to read the legislative history as authoritative, then we have to read it carefully and see that the reaction was really about this barrier to an actual housing project.
Why then even take it up as urgency legislation? I mean, your view is that the legislature was wide-eyed about the fact that this issue could continue to be litigated for presumably years to come. Then why even do it as urgency legislation?
Well, because the legislature wasn't trying to address the long-range development plan, it was addressing the actual housing project. Because the purpose of this exemption, limited exemption, is to encourage the actual construction of housing. And they weren't addressing...
And Mr. Lippy, they talk about the language in the statute that they used is the effects of noise generated by project occupants and their guests. And the entire controversy, it seems clear, related to students making excessive noise. They broadened it to be project occupants, which would be the students, but broader than that because there is also a component of the housing that's supportive housing, so it's not just students. It seems incongruous that they would then allow the analysis of these impacts, again, for increased population, which is students, and to then turn around and allow a broader analysis of social noise impacts from these individual project occupants, students, whatever the term you use for them, the people, that then go off-site, not at the actual housing, but go off-site and are too loud and are of concern to the residents. I mean, isn't that the entire thing? Wasn't that the concern to begin with, the concern that the legislature was attempting to address, and the same arguments you're making now, you're just making them more broadly?
I think the difference is, or the key to the response to the question, is that many of the students who go to UC Berkeley aren't going to live in new housing projects. And as I was saying, the legislature's purpose was to remove barriers to the actual construction of housing. There's 39,000, 40,000 students now. Only 9,000 of them are housed in UC's housing. Of the increased, once we have the increase, according to the LRDP, there'll still be 8,000 students who aren't housed by UC. So there's a whole lot of noise being caused in the community by people who are not going to be occupants of new residential projects for which the legislature is attempting to remove a barrier to the construction of those. So it makes perfect sense for the legislature to leave a broad requirement in CEQA to look at and investigate the social noise impacts of increasing population, because that doesn't interfere with a residential project construction.
Would they then separate, how would they then separate noise from students who live there versus noise from students who don't?
I don't think they would at the programmatic level. In other words, for the program, you simply would come up with a method, which the expert hired by my clients did, to analyze the effect of the noise of having that many more students in the city. I mean, let's face it, some colleges have a party culture. My daughter went to UC Santa Barbara, lived in Isla Vista. She said that was noisy pandemonium. UC Berkeley also has a party culture. So that would be the focus of the analysis at the LRDP
I don't know,
level.
I don't know if that's in the record, but.
It's a matter of argument here. So I do think that it's important to continue to look at the definition. I mean, I talked about the definition of residential project in 21159.28. The same is true of the new definition of residential project in the part of AB 1307 that addresses the alternative site analysis. Again, it's a definition whose purpose it is to provide a way to remove barriers to the construction of housing. And so having CEQA require social noise analysis of the long-range plan simply doesn't interfere with the actual decisions to construct housing.
Council, can you tell us where you part ways with your opposing counsel in terms of how to parse residential versus non-residential in terms of the long-range development plan?
Well, the long-range development plan authorizes dozens of non-residential projects, campus life projects, academic buildings, redevelopment of many sites for non-residential purposes. And that's on pages 9574 and 9575 of the administrative record that's part of the EIR. It's a very long list of projects that are not being authorized at this time. By authorizing the LRDP or approving it, there's no authorization for any of those projects to be built. There's also a couple of dozen residential projects there, and they're distinguishable by looking at the number of beds. The non-residential doesn't provide beds, the residential does. But I think the court's question is really about the impact analysis, and I'm not sure if it's different than Judge Guerrero's question of how do you distinguish, and I don't think you do at the programmatic level. At the project level, where you're actually going to decide to build houses or residences, then you have a distinction that's very clear. The legislature says you don't have to do it. I'm not sure if I answered your question, but if I understood it correctly, that would be my answer. But I wanted to go back to the definition of a residential project in AB 1307 in the context of the alternative site analysis exemption. And it refers to a project consisting of residential uses or a mix of residential and non-residential uses with at least 2/3 of the square footage of the development designated for residential uses. And again, what you see here is the legislature saying, if it's primarily residential, then you're going to get a limited pass from some CEQA procedures and analytic requirements. But you're not going to be able to slip a few residences into essentially a non-residential project and get that kind of pass. And again, it's about removing a barrier to production of actual construction of houses. So again, I don't think the LRDP having to do this kind of analysis is such a barrier, because every single residential project that's projected to be potentially approved in the future will have the site-specific analysis and the site-specific exemption when it gets there from that requirement of analyzing social noise.
Even under your analysis, Mr. Lippy, you concede that the People's Park project is going to be built. Is that correct?
This case provides no platform to stop that. I would concede that. Whether they actually build it or not, that's up to UC at this point, and any other efforts that might be made by the community. But certainly this case is no longer a threat to stop the People's Park, housing project number 2 that's proposed at People's Park. So, the other body of law that the legislature is presumed to be aware of, other than the Keep Our Mountains Quiet case law and that kind of case law, is the requirements of Section 21080.09 and the Education Code, Section 67504. And those statutes, especially the CEQA statute, requires that UC must analyze the environmental impacts of its campus population plans in an EIR for the long-range development plan. And so the legislature, by choosing the word residential project, explicitly did not reach out to encompass the long-range development plan. It could have easily done so. But again, it was urgency legislation to address a crisis in Berkeley. I mean, it's not just Berkeley that has a housing crisis, but in Berkeley it's very acute, especially for students. 10% of the students in the graduate and undergraduate levels have experienced homelessness. And so this very precise focus of the legislature is clear again because it would have been the easiest thing in the world to amend Section 21080.09 to make it clear that the LRDP's EIR doesn't need to do this, and they didn't do that. And so I think that kind of statutory construction principle should outweigh these, what I would consider to be almost Trojan horse statements in the legislative history. The court's authorized to do with it as it sees fit, but the legislature as a whole did not vote to change Section 21080.09, and it easily could have. The other statutory construction principle that I think applies here is using the words where they appear as in the same way that they are used elsewhere in the statute. And the word project is used. The word program is not used. Long-range development plan is not used. Project is the specific authorization to undertake an activity that changes the environment. I just want to spend a moment on, actually I probably should move on to the alternative locations, but one last comment, just that if we establish that AB 1307 doesn't affect the LRDP, then the only remaining question is whether there's a fair argument. And UC has not really made much of an argument that there's not substantial evidence supporting a fair argument of significant noise impacts. What they say is that it's speculative, and the reason, the underlying reason they say it's speculative is because it is attributing behavior to an identifiable, or I think the phrase used was identity-based judgments. And this goes to this notion of people as pollution. And to me, that's a public relations strategy that has become a legal argument, but it's actually not a legal argument for the simple reason that students are people, and all people cause pollution, whether it's water pollution, air pollution, noise pollution. And students are not some special class of people who don't cause pollution. They do. So it's no different than saying that people are not pollution. Well, that's fine, but they do cause pollution, and every single environmental law that we have on the books at every level is there to regulate people's behavior that causes pollution. So to me, it's a meme, it's a bumper sticker, it has no legal force and no substance to it. So moving on to the alternative locations issue. So my client's view here is that the court should decide this issue, even though it's technically moot, because the alternative location analysis no longer applies to this project because it meets the criteria of the new section 2108.5.2. And the reason the court should decide this issue is because as this case has progressed, it's kind of like peeling back the layers of an onion. What are UC's real reasons for not doing alternative sites analysis? Well, they had some reasons that they stated in the EIR. The Court of Appeal rejected those reasons because they weren't supported by the record or they were contradicted by the record. For instance, the notion that there would be a diminished number of beds if they chose an alternative location to People's Park for this housing project. In fact, that's not the case. The record contradicts that. There's plenty of beds that are in the housing program. There's 2,000 more beds in the locations that are projected in the housing program than they even intend to build in the future, 13,800 versus 11,000, about 100, almost 3,000 more. And then there's lots more evidence that very specific sites would have the ability to provide more beds than the People's Park location. And then you had kind of the second layer of the onion, which is UC's arguments to the Court of Appeal that were not included in the EIR. For instance, that it would be inconsistent with a project objective. The project objective that they pointed out was, one of our objectives is to revitalize a property that UC owns. Well, it doesn't refer to People's Park. People's Park is just in the project description. So the whole body of project objective law that deals with project objectives is a limitation on what kinds of alternatives need to be considered doesn't apply because it's not in the project objectives. And then you get to the final layer of the onion, the deepest layer, which is what they've argued to this court, which is that we in our long-range planning process have spent years wanting to build in People's Park. And therefore, we don't need to involve the public in the EIR's analysis of alternatives. And the phrase used in the briefing was it would be pro forma to do that. And that's so fundamentally inconsistent with CEQA. As this court's many decisions have held involving the public disclosure, public participation, key purposes of CEQA. And this court has described the EIR as the heart of CEQA and the alternatives and mitigation part, the core of CEQA. And when you talk about CEQA, you're talking about public participation. UC doesn't want to do that. And it took all this time to get to the Supreme Court before they just came clean with their true reason for not wanting to do the alternatives analysis. And my clients have litigated this case. Community groups have litigated many cases against UC trying to ensure compliance with CEQA. This court should decide the merits of this issue and the merits of that position. That is the petition for review that they submitted. The actual issue that they asked this court to decide is, under CEQA, when a lead agency has identified potential sites for future development and redevelopment in a programmatic planning document, is the agency required to revisit alternative locations for a proposed site-specific project within the program, or would such a requirement infringe upon the lead agency's discretion to prioritize and propose sites in the manner that best serves the agency's goals? That wasn't in the EIR, but that's what they've asked this court to decide, and we agree the court should decide that because we don't want to go back and have another onion, we being the community groups that I've represented. The public does not need to go back.
But counsel, doesn't 21085.2b decide it? Doesn't it resolve the issue? Or are you saying that the substantive requirements, either B1 or 2 or both, were not met here?
No, it resolves the issue as to the housing project that's proposed at People's Park. But we're asking the court to decide the claim anyway because it's likely to recur because UC's dug into this position. This is what they believe, that because they have this long-range planning process, if in the privacy of their own deliberations that they've considered alternative sites, they don't need to involve the public in that decision-making by putting that analysis in an EIR. And so it's likely to recur, it's likely to evade review, it's in the public interest for this court to decide that that's not how CEQA works, that the public has the right to be involved in that decision-making and have the reasons for alternative sites not being chosen made clear in the EIR. Right?
Even if it is likely to recur, is it actually likely to evade review? Couldn't someone who's opposed to whatever future action is taken challenge that action?
Well, the reality is that citizen groups do what they can. And here you have a very practical problem. Some of the cases I cited is against UC in the request for judicial notice, whereby other citizen groups that I happen to represent against UC regarding its CEQA compliance. That citizen group, Save Berkeley's Neighborhoods, wasn't able to continue. So 2 new citizen groups, in this case, became plaintiffs and carried the torch further on both enrollment impacts and alternatives analysis and all the issues in the case. But there's a limited amount of resources available for that kind of litigation. So it's likely to evade review because it's just very difficult to mount this kind of case from a community-based organization looking for fundraising to pay its lawyers and to do all the things that need to be done. So it is likely to evade review, and we are here. We've been litigating this case for years, and UC has asked the court to decide the issue, and we think the court should so that we don't have to do it again in a new case.
You have about 3 minutes left.
Thank you very much. Yeah, I just wanted to talk about the citizens of Goleta Valley versus Board of Supervisors decision, the so-called Goleta 2 decision. It's really the only authority that UC cites for its position that it can do this analysis or do the consideration of alternatives in private. But there's a very specific set of facts in that case. The court had, or the EIR had been sent back twice to look at alternatives, had looked at more alternatives, and then on the third round, there was yet another set of alternatives that were brought forward by the plaintiffs and said, oh, you have to do those too. And I think the court expressed clear frustration with that kind of iteration or back and forth. And it looked to the fact that there was a local coastal program that had been reviewed by a CEQA equivalent process, in a public process. Right? It wasn't just in the privacy of the agency's own conference rooms. That they had looked at alternatives, and that was part of the rationale for the court to say, you don't have to do any more alternative analysis, we're done. So it's a very specific set of facts, very distinguishable from this case, and the key fact is that there was a public review process for that alternative selection process. And just, I'll close with the fact that the alternative kind of analysis that needs to be done is to compare the project proposal with alternatives, in this case sites, that might have less environmental impact. This project has a significant environmental impact on an important historic resource. It's a City of Berkeley landmark. It's on the California Register of Historic Resources. It's on the National Register of Historic Places. And so for UC to override that without going through CEQA's process is very inconsistent with CEQA. If they do it in a CEQA process, as opposed to the private deliberations, they have to determine if some other place is feasible, and if it's not, that overriding considerations, social benefits or economic benefits, warrant accepting that amount of environmental harm. And they avoided that entire aspect of CEQA here. And again, it's important for this court to instruct UC, and it wouldn't just be for UC, it would be for all agencies. If UC's principle, if adopted by more agencies, then this issue would have to be litigated in all sorts of contexts. So thank you very much.
Thank you.
Thank you. I would like to just start where Mr. Lippy ended on alternatives and encourage this court not to issue an advisory opinion, which is all that it would be at this point due to the concessions and the new legislation that addresses the need or lack thereof to look at alternative sites for the People's Park project. There's no way of knowing what UC is going to do in the future when it looks at the projects that are going to come forward under the long-range development plan. As to the questions that your honors have asked about noise, I think, Madam Chief Justice, your questions are right on point about the legislation and the legislative history and the reasoning that the legislators have given us here. I think we can look at it sort of in context of a trajectory from going from the trial court's opinion, which correctly decided that social noise, this type of noise from people wandering about neighborhoods in their private lives, was not an environmental impact under CEQA. Then the Court of Appeals opinion came in and sort of took this left turn and precedent-setting step. The legislature stepped in with the urgency legislation to the extent that the legislation isn't as explicit as opposing counsel would ask it to be or would require it to be. The legislative history definitely shows that the intent was to cover people. That's what they mean when they say the people, occupants and their guests. They mean people, that CEQA is not meant to regulate people. And yes, people cause pollution, but never before has a court said that the people themselves are the pollution. And that's the distinction between even the Keep Our Mountains Quiet case, where yes, there was crowd noise, but it was from the project location itself. Nobody looked at what people were doing when they wandered off past the after the wedding that they might have been attending at that case. So I think the key here is people, and not to introduce the stereotypes that we're hearing about UC Berkeley having a party culture. Clearly that's not appropriate it's not on the record, it's not appropriate in CEQA. And I think the true target of the project opponents' challenge is really clear, that it's about undergraduate students. It's been the history of this case, and the cases that Mr. Lippy referenced is the Save Berkeley's Neighborhood cases have tried to limit student enrollment at UC Berkeley, and the legislature has stepped in twice now to try to avoid that result. So I would just encourage this court to uphold that legislation and the history of CEQA, because I do think interpreting it in this way is the most protective of the environment. It is the way that does not discourage urban development. And so we ask the court to undo the Court of Appeals' erroneous conclusions as to both social noise and alternatives, and direct the Court of Appeal to adopt, with directions for the trial court to judgment to be affirmed. If there are no other questions, I will conclude.
Thank you very much to both counsel. We appreciate your arguments. The matter is submitted.